Helping parties with problem solving. While helping parties with problem solving is always part of a mediator's job, it takes on heightened importance when self-represented litigants are involved. Most self-represented litigants simply do not have experience working through legal disputes. You are the problem-solving expert in the room, and you need to bring that expertise to bear when working with self-represented litigants. Because of the lack of training and experience in legal problem solving, many self-represented litigants will not appreciate what information is important. They will also not engage in problem-solving best practices, such as seeking information, sharing appropriate information, and sufficiently exploring alternatives. One of the obstacles that many self-represented litigants confront is the lack of information, particularly information about the legal process and the law. Mediators can help self-represented litigants overcome this obstacle by helping them identify and obtain the necessary information, including information about law and legal process, when it helps the self-represented litigants meaningfully participate in the mediation process. When a mediator helps a self-represented litigant obtain information about facts or law, this empowers the self-represented litigant to know more about their claim, to know more fully the strengths and weaknesses of their claim. And this, in turn, balances power between the parties in the mediation. In this section, we will demonstrate how mediators can assist self-represented litigants to engage in good problem solving by engaging in the following behavior: information gathering and information sharing. In subsequent sections, we will work on other aspects of good problem solving. Moreover, we will highlight ethical considerations as we work through the problem-solving process. Helping the self-represented litigant broaden their information base is one of the most important jobs mediators can do. Good problem-solving requires good information. Thus, the first job of a mediator is to examine the information upon which a party, especially a self-represented litigant, bases his or her claim or defense, and then seek to expand that information base. Information sharing is also an important part of problem solving. Parties in conflict often stop sharing information because they believe that sharing information will weaken their negotiating position, or they simply will stop communicating altogether. Mediators should encourage participants to share important information and their true concerns. Parties are often more willing to do this in separate sessions, which are confidential or can be confidential, with the mediator. The mediator can then use the information to help the parties come to mutually acceptable agreements. Questioning is another primary tool that mediators use to not only understand the conflict for themselves, but also to help the parties assess and expand the factual information so that settlement decisions can be made on as complete an information base as possible. Before we get into the specifics of good questioning, let's discuss debate versus dialogue. This is an important aspect for mediators because many parties will come in trying to debate issues when dialogue might be more appropriate. So dialogue is thinking together, and debate is imposing thought. When you're dealing with dialogue, you can come up with a mutually acceptable answer to the problem. When you're dealing with the debate, it's often about power. It's often about trying to be right. And so for the mediator, the question has to become, do the parties want to be right, or do the parties want to solve the problem? If they want to be right or wrong, then there's a place to do that. It's called a courtroom. If they want to try to solve the problem, the place to do that is in mediation, but it requires a different kind of communication. Let's talk in more detail about the distinction between dialogue versus debate. Dialogue is about discovering. Debate is about knowing. Dialogue is about explaining. Debate is about arguing. Dialogue is about listening to understand the other side, and debate is about listening to criticize and find holes in the other side's argument. Dialogue is about acknowledging feelings and emotions, and debate is about ignoring feelings and emotions. And finally, dialogue is about seeking a solution, and debate is about defending a solution. The mediator needs to try to keep the conversation to the dialogue column more than to the debate column. Although the parties, as we've discussed in other parts of this training, will often want to keep the dialogue into a debate column because of the culture of debate and argument that we have, especially if there is an attorney present for one of the parties. Now let's turn to the type of questions that can help parties, self-represented parties in particular, to understand their factual information better. There are two types we're going to discuss: gap questions and justification questions. Using questions to fill gaps is one of the mediator's real skills. Mediators using questions to help identify gaps in dispute narrative. Mediators can and should use their knowledge of the legal system, law, dispute resolution principles to understand information that they know is likely relevant but that the party, particularly in the self-represented litigant, simply has not communicated. Let's look at a gap question example. Consider a landlord-tenant dispute where the landlord evicted and is seeking back rent from the tenant who moved out before the lease expired. The mediator might ask the landlord, "You didn't mention if you had re-rented the apartment, have you?" And so here, the mediator may understand that there's a duty for the landlord to mitigate. And so instead of saying that, the mediator simply can ask the question and begin to help the landlord realize their duties and the kinds of facts that might be relevant to a judge later on if the mediation doesn't result in settlement. Let's watch Pauline, serving as the mediator in our own landlord-tenant scenario, use gap questions to help the self-represented litigant to understand her situation more fully.
In terms of your dogs, tell me a little bit more about them. What breed are they? You mentioned they were pit bulls, or did you?
They're pit bulls.
They're pit bulls. Okay.
Yes, I've had them since they were puppies, since we all moved in together 2 years ago.
Okay, and they get along with people. They're nice. They're friendly.
They're sweethearts.
They're sweethearts.
Yes.
Okay.
I took them to obedience school. They graduated. They both have certificates. They've been great. Absolutely wonderful.
Yeah, I can see you're very proud of them.
I am.
Yeah. So, where can you see at all why Carla might have given you these notices for the dogs and asking you to find another home for them? Can you imagine any reason why she might ask you to do that after all this time?
To be honest, I think it's just so close in time to the time that I asked her for repairs to my apartment. I understand that my dogs are pit bulls and there's this terrible stigma about them, but my dogs are nothing like that. They're sweethearts, and because I do live alone, they're a little protective in the sense that they'll let me know when someone's at the door, and because they're used to barking a little bit when someone is at the door, they may even do it when I'm not home. I'm not sure, but they're in no way dangerous or deadly to anyone.
Okay, but you did mention barking as your dog's response to maybe having someone at the door that they're not familiar with, things like that. Is it possible that their barking might scare people or, cause people to be concerned about safety, anything like that?
Well, I think because they're not golden retrievers barking, for example, because they are pit bulls, there may be this stigma that because they're barking, they're going to be outrageously dangerous or ferocious.
Could you see how Carla might take some of the things she's heard from the news or stories that she's heard and be concerned about the unpredictable nature of how a pit bull might react if they get triggered a certain way? Can you see how she might be concerned about something like that?
I mean, she's known my dogs since they were puppies, babies, but I can see how some of that might affect her.
And what do you think from her perspective?
In this last segment, the tenant left certain holes or gaps in her story. Pauline used gap questions to help fill in some of these holes so that the tenant would have a better understanding of the concerns that are part of this dispute. Some of the questions that Pauline asked were, what were the breed of the dogs? That was something that the tenant didn't even mention. They were pit bulls. What reasons did the landlord have to have concerns about the dogs? This was something that first the tenant resisted, and then Pauline asked, well, can you imagine any reason that the landlord might have, considering some of the news articles in the press about pit bulls? These things help the tenant see some of the concerns on the other side and also added facts that paint a more accurate picture of the story. Very frequently, self-represented litigants will leave these holes, not necessarily intentionally, but not see all of the other points that the other side might make. A lawyer is trained to see the holes in their argument, but not so the self-represented litigant. So, asking gap questions helps the self-represented litigant see the case more fully, and as a consequence, empowers them to make better decisions, thereby balancing power in the mediation. Justification questions. Asking justification questions is a form of reality testing that probes the plausibility of the party's claims. Without the mediator making explicit judgments about the merits of a party's case, the way an evaluative mediator might, it directs the parties' thinking to how persuasive their arguments and allegations will be to a trier of fact or decider of law if they go to court. An example of a justification question a mediator might ask a tenant in a landlord-tenant dispute might be, what is the basis that supports your decision to withhold rent? It is often surprising how effective justification questions can be when a self-represented litigant can't articulate the reasons why he or she has withheld rent in any kind of convincing way. And again, even though the mediator will not use a judgment or evaluate the answer, the fact that the self-represented litigant is stumbling through and can't really see and believe their own argument is often a way to increase flexibility in their dealing with the other side and reaching a solution. In this next vignette, I'll be serving as a mediator in a different landlord case, and I'll be using justification questions to help the landlord revisit some of the justifications or the arguments that he is going to make in court to have the tenant evicted. There are several issues, but I'm going to be focusing specifically on the landlord's concern of the tenant having a pet parrot in the apartment. Let's watch. So, we've made a lot of progress. I mean, the rent and the stove, are fairly set. I thought you all did a great job in trying to work out this front door paint, and inside you showed a lot of flexibility, which I'm sure Anna appreciates. But obviously the parrot, is we're at a sort of a sticky point here, right? So I wanted to just get a little bit more information about it because that might be helpful to us. So you talked about the safety concerns with the parrot. Can you just tell me more detail? I just want to get a better sense of what was said and who said it.
Yeah, I had a couple different reports from a couple different units about the parrot squawking, and they were scared that it was going to fly into their apartment and get in their hair and attack them. I mean, they come in anonymous and they say they're from different units, but I'm pretty sure it's mostly one person. It's Mrs. Green, and she's up in 403. Okay. And she kind of takes it as she's the neighborhood watch of the eyes. Okay. And, I have almost a standing appointment with her every Friday morning to go over who's doing what in the building. So. Okay. Have you seen the parrot do anything aggressive or personally? No, but I'm not there all the time. Okay. So I don't. If they say it, I have to take them at least. I have to take them at their word. Okay. And your sense is maybe that this is all coming maybe from one person. Yeah, and if it is who I think it is, it's not the first time that she's kind of blown something out of proportion or made a big deal out of nothing. Okay. And I know you have the no pet clause in the lease. Have you been flexible with that in the past or now? Are there people who have pets or have had pets in the apartment? I don't think there's any pets now, or at least there's not any that I'm aware of. Okay. I know in the past, every once in a while, there's been, a couple people have had cats every once in a while, or there was a little poodle, a little tiny poodle that an old lady had a couple years ago that we kind of let slide because it was the kind of only really thing that she had. So. Okay. So it's a policy that you've shown some flexibility on in the past. Well, we at least haven't taken action against that person because of it. Okay.
So in this last section, I asked 3 kinds of justification questions to help Matt revisit and rethink some of the arguments that he's making in this mediation. One is, where were the complaints coming from about the parrot? And when we dug a little deeper, we found that it was likely that the complaints were coming from one person who's known as a complainer. Two, I asked, had Matt seen the parrot act aggressively personally? And it turns out he hadn't. And then three, have other people been allowed to keep pets in the apartment? And it turns out that Matt had been somewhat flexible in this in the past. So all of these undercut his arguments concerning the parrot in this case. Justification questions is a facilitative way of getting the participant to think more deeply about their arguments. When Matt is unable to come up with really strong answers that support his claims, even if he doesn't admit it to the mediator, he's going to think more deeply about the strengths and weaknesses of his case. And because those answers weren't strong, what's going to happen is he's going to be more flexible when working with the other participant. And again, in this case, both sides are unrepresented, but in particular, if one side wasn't represented, this would help to balance power. Justification questions are similar to gap questions, but in justification questions, you're searching specifically for the underlying arguments and having them to articulate those to you. And if they can, well then, they may have a stronger claim, and when they can't, they're going to be thinking more critically about their own claim, even if they don't admit it to you. Justification questions are important because they help the participant to understand their claims and defenses more objectively. But sometimes, with justification questions, the party will not understand the law in a way that will be beneficial to them. In such circumstances, it may be prudent to refer the self-represented litigant to resources outside of the mediation. This could be stopping the mediation to refer them to legal counsel or refer them to free resources that are available on the internet and elsewhere that will help to explain the law that's relevant to their case. This is something mediators can do and often should do, and should be aware of the variety of resources available in their practice area and in their location. Brainstorming, generating and evaluating options. Sometimes the obstacle self-represented litigants face in mediation is a lack of awareness of the range of possible ways a problem might be solved outside of court. When they come into the mediation, often the solution they have is the most obvious solution to the problem and certainly the most self-serving solution to the problem. The lack of this type of information often prevents self-represented litigants from making wise settlement choices. Brainstorming is a highly formalized discussion best used when the parties are more polarized and when creative interest-based solutions are highly likely. Brainstorming is divided into two parts: generation and evaluation. A key role of the mediator is to guide the parties in following the brainstorming rules. When brainstorming rules are followed, the mediator helps the parties expand the range of possible ways a problem might be solved, which makes the potential resolution more likely. Once you take the self-represented litigant through a brainstorming process, this empowers them to look at many different options. In other words, you're overlaying a very powerful problem-solving process that they would not use for themselves. And consequently, you make them more powerful in the negotiation, balancing power. You give them tools that they do not bring to the mediation itself. This is totally ethical because you're trying to enrich the whole process, but in doing so, you're enriching the self-represented litigant's power as well. Stage 1, brainstorming. Generate options. In this stage, here are the rules to think about when you're trying to help parties to come up with options that possibly can solve the problem. When you do this, you can do it when the parties are in the same room if there's a certain level of cooperativeness, or you can do it in separate sessions, in separate meetings with each of the parties and or their attorneys present. Here are the rules. All ideas are welcome. Parties are encouraged to feed off each other's ideas. That could be the attorney and their client, or it could be the parties in the room together. No interruption or criticism is permitted. This is very important. The idea is to generate as many options as possible. And what you can do is say, listen, we want to spend the next 10 minutes and we want to generate 5 options. No matter how ridiculous they may seem, the idea is to generate 5 options that we think might work. Without criticizing them, we're going to go look later and see which options are practical. And no evaluation is permitted. This is very important. If people start to evaluate the ideas as they're generating them, what tends to happen is people don't want to throw out ideas because they're going to be criticized. Here is some behavior that you need to help the parties to avoid, whether you're working as a group or whether you're working separately with the parties. First, help them to avoid premature judgment as to the solution. As I mentioned before, the parties will often come into the mediation room with a solution in mind, which is fine. You just need to help them to be flexible and at least consider other possible solutions and help them to do that not early in the process but later in the process. Searching for a single answer. In problem solving, there is no silver bullet. There are always more ways to solve the problem, and it's a question of coming up with as many as possible. Assumption of a fixed pie. This idea that the more she gets, the less I get, and vice versa. And as we know in problem solving, sometimes there are very meaningful trades to be made in which both sides gain. And then finally, and maybe more importantly than anything, thinking that the problem is the other side's problem. In mediation, both sides have to agree to solve the problem. Thus, you as the mediator have to help the parties to see that it's in their interest to make sure that the other side's concerns and interests are at least minimally met. Otherwise, there's no reason for them to settle the case. There's no reason for them to give consent to settle it, and therefore the problem will have to be resolved in court. In this next video, let's watch Pauline, serving as a mediator in an unlawful detainer case, help the self-represented litigant generate and see some additional solutions to her problem.
So, Marissa, we've talked a little bit about your situation and some of the priorities for you at this point. Before we kind of go into what the outcome may be for you today, why don't we spend just a couple minutes together and talk through what are some possible outcomes that can come from today, or if it doesn't resolve today, what are some possible things that could be in your future in terms of the situation? So what are some things that you think might be on the table at this point?
Well, based on what we talked about in our pre-mediation meeting together, I did bring some notes with me today about insurance plans, pet insurance. So I looked through some of the plans, I did some research, and it seems like this may be workable for me. I may be able to afford, because they're pit bulls, the plans are a little more expensive, so they range from $50 to $100 a month. I may be able to do the $50 a month, and that covers up to $50,000 in damage.
I see. Great.
And so.
Okay, so thank you for looking into that. I know that's how we left our conversation last time as one of the options as to how this might be resolved. Can you think of any other possible ways on how the situation can go from today? Both assuming something gets worked out here, or if, let's say, something doesn't get worked out here, going to court is still something that you have to think about.
Right, I've thought about it over the weekend. I thought about the possibility of moving.
Okay.
Although it's not something I necessarily want to do. I'm comfortable where I'm at, but it's a possibility.
Sure, yeah, we don't have to make a decision now about whether something's workable or not workable. We're just trying to get as many ideas or as many possible outcomes out there as possible so we can take a look at the bigger picture, or the full picture, and to see if there's a way to make sure that no idea gets left unthought about or not thought about. Okay?
Okay.
So moving, you mentioned, is something that you've thought about but you don't prefer to do.
Right.
Going to court is something that's still kind of hanging out there as of this point in time. What are your thoughts on, and have you ever had an experience with paying a pet deposit either for these dogs or any other pets before at any other place?
Yes. Moving in, I paid $300 per dog.
$300 per dog.
So yes,
okay.
so I did pay a pet deposit.
Okay, so just to make sure my math is correct, so you put down $600
yes.
When you first moved in.
That's correct.
Okay. And Carla mentioned a couple times during the joint session or when we met together earlier that she's nervous about liability and in the context of her workers and other people coming into the unit to make the repairs that you've requested specifically. Are there any ways that we can maybe help come up with ideas that may not cause her to be so nervous with the dogs in the space while maintenance people are in there or working on your unit?
Well, I thought a little bit about that as well, and I thought perhaps I could keep the dogs in their kennels. If she were to be able to provide me a time or at least a range of hours within which they would come to the apartment, I could probably keep the dogs in the kennels for that time.
Okay. And I'm grateful for your willingness to think about this and consider these options as possibilities at this point. Again, I'm not asking you to make a decision, just generate.
Once several possible solutions to the problem are generated, the mediator can help the parties move into stage 2 of brainstorming, which is the evaluation stage. In this stage, once the solutions are laid on the table, now the parties can begin to, again, either separately or together, determine how the option satisfies their relevant interests. And this is important. It has to be both sides' interests. How are all of the parties who are part of the mediation's interests served in this particular solution? Determine how practical it is. Discard the worst solutions or options that don't really make much difference. And then finally discuss the best options. The Maryland Judiciary study of day of trial mediation also has something to say about use of brainstorming. Under the study, brainstorming is considered an eliciting technique, and those techniques include asking participants to suggest solutions, summarizing solutions that have been offered, and asking participants how those solutions might work for them. The study found that eliciting techniques or strategies were positively associated with the parties reporting that they listened and understood each other and jointly controlled the outcome, and that the other person took responsibility and apologized. Eliciting strategies were also positively associated with reaching an agreement. The study found that the long-term outcomes for mediators using these eliciting tactics or strategies were that participants were more likely to report a change in their approach to conflict and were less likely to return to court for an enforcement action.
You will now be directed to a short quiz to assess your understanding of the information just presented.